Hello everyone. Thank you for coming. Good evening. Right. Firstly, forgive me. This is my first time of doing such a large event. It might not seem large to some people, but to me, it's very large. Thank you for joining us tonight at Anthony Webb Estate Agents' first ever landlord event, The Future of Lettings After the Renters' Rights Bill. The Renters' Rights Bill, once passed, will bring about the biggest changes to the private rental sector since the 1988 Housing Act. There's been plenty of speculation and misinformation in the press and on social media. Tonight is about cutting through that noise. We are here to give you a clear overview of what's coming, dispel some myths, and help you understand how to stay compliant and protect your investments in the years ahead. At Anthony Webb, we believe it's our responsibility to support both independent landlords and those already working with agents if you self-manage. I forgot to do this bit. There we go, that's me.
Welcome to our presentation.
No, that's it. Sorry. A little about me. My name is Tony Ourris and I'm the director of Anthony Webb Estate Agents. We recently celebrated our 25th anniversary and I've personally been in the property industry for almost 40 years, including as a landlord myself for most of that time. Anthony Webb have been proud to receive many industry awards over the years, most recently this week winning the ESTAS 2025 Best in Postcode Award, announced last week by TV personality Phil Spencer, alongside recognition from the British Property Awards for Lettings and the Best Estate Agents Awards for Sales. Tonight you will hear from three leading experts. Susie Crolla, she's the CEO of the Guild of Letting and Management. Andy Halstead, CEO of Barbara Insurance Group, who own HomeLet, the reference company that we use, and Rosanna Yarlike, that's it. Is it Yarlike? That's it. I knew I'd get that wrong. Litigator at Fiery Law in Whetstone. Now for some housekeeping. The fire exits are located to the left and the right. Toilets can be found at the main entrance. Please silence your mobile phones during the presentations. Tonight's event is being recorded and will be shared with you via email once ready. After the presentations, we will have a Q&A panel session, followed by networking, drinks and some sandwiches, provided by the Chicken Shed Theatre. We aim to finish the formal part of the evening around 7:30 p.m. It might be a little touch earlier. Our first speaker tonight is Susie Crolla. Unfortunately, a few hours ago, about 2 o'clock, I received a call from Susie where she told me that she had become unwell. Susie has kindly recorded a voiceover of her presentation over her slides, which we will play for you today. Susie Crolla is one of the UK's most respected voices in landlord and tenant law. As CEO of the Guild of Letting and Management, she has spent over 19 years educating landlords and agents, including ourselves, across the country. Tonight, Susie will walk us through what landlords must prepare for under the new rules and how to stay compliant. Please let's start Susie's presentation.
Welcome to our presentation related to the Renters' Rights Bill and looking forward. My name is Susie Crolla. I'm Managing Director of the Guild of Letting and Management. I've been a qualified trainer and moderator and examiner for the last 36 years. I'm legally qualified, specialising in property law, commercial and residential, private client, commercial law and intellectual property. I'm really sorry that I can't be with you this evening as I'm very unwell. However, I do hope this presentation is beneficial for those attending this evening. So the key points of the presentation this evening relate around the bill and the fact that this bill will become law and will be enforced at some point in 2025. One of the main reasons for this event this evening is so that landlords can educate themselves, obviously with the support of Anthony Webb and the team. It's important that landlords engage in discussions with providers and stakeholders, and in doing so, they will start implementing change and putting in place an action plan. Because one of the most important elements as the bill progresses towards royal assent is that preparedness is key. So it's very, very important that you take away as much as you possibly can from this evening. So where are we in the journey of the Renters' Rights Bill? The bill itself was introduced to Parliament last year in July and is making very good progress in the sense that at the moment the bill sits within committee stage, which I've highlighted in red for you. Now, what does that mean? That means that there will be 6 sessions in the House of Lords where the peers will discuss certain elements of the bill, well, not certain, all of them, and decide what elements need to be amended. 3 of the 6 days have already taken place, and the committee stage will end on the 14th of May. Following that, the report stage and the 3rd reading will take place, and then we move forward to the final elements, these final considerations, these final steps before the bill receives royal assent and becomes an act. So the Lords are debating what needs to happen, what needs to change, and they must consider every single element. So one of the key things that no doubt will be discussed by some of the other speakers this evening is whether landlords will be permitted to take rent in advance, for example. There's also some concern about the courts and whether the courts will be ready for any changes that are implemented throughout the next few months. So what do we know? We do not have enough time to discuss the whys behind these changes in legislation, but what we do know is that the law will change. The press, for some reason, want landlords to panic. Some of the information out there that you may have read or may have come across is actually incorrect. Landlords will have support, and obviously that's why you're here this evening. And most of the comments being made by the press, tenant organisations, the government does not actually reflect the type of landlords in this room. So it's clear from the last almost a year that the bill is aimed at a certain type of landlord. So this is what you need to prepare for. All of these elements on screen are actually elements of the bill that you will need to deal with. So one of the key points is in pink, and it sits around the abolition of Section 21. This element of the bill has been discussed at length since 2019. And it's the fact that abolishing Section 21 is going to be a problem that has caused panic in the industry, especially for landlords who are worried about the method and how they will get the property back if they need to serve notice. And that will be addressed by one of the other speakers this evening. Obviously, if there is no Section 21, we would need to rely on the Section 8. And the Section 8 is in the process of being updated with new grounds, new notice periods, and a more robust process in relation to evidence being required. Alongside that, we have the points relating to increasing rent, how rent can be increased, what tenants can do if they're not happy with the rent increase, and the role that the first tier tribunal will play in relation to those challenges if a tenant were not satisfied with the increase that has been proposed. There are also some very key elements relating to landlords. An element that we've never had before is that landlords will have to become members of a new ombudsman service. Now, the landlord ombudsman has already been identified. Officially, that announcement has not been made. But it's important to understand that the landlord ombudsman in the future will deal with any complaints that are put forward by tenants in relation to a tenancy or maintenance or disrepair and so on. So it's very important to understand that landlords will have an obligation which is mandatory to join the landlord ombudsman service. Another element is the private rented sector database. Now, again, this has never appeared within the private rented sector. It's not something that we've ever had to deal with. It's not something that landlords have been required to do as part of being a landlord. I would probably think that the closest system to this is selective licensing. Now, some of you operate your businesses and properties within selective licensed areas. One of the things that I would like to highlight here is that the private rented sector database will be nationwide in England, and every single landlord will have to register every single property, residential, not commercial, that they own onto the private rented sector database. So again, it's new, it's quite onerous. Obviously, you will have to make sure that your properties have been properly audited and that you have the correct information to upload on the database when this database becomes available. There are also other elements that you can see on screen that have been addressed, but I would say not formally through legislation. And those two elements sit at the top of the slide and relate to discrimination. So the Renters' Rights Bill will become a vehicle for banning, blanket bans effectively, on landlords who refuse tenants who are in receipt of benefits and refuse tenants because they have children. So this is something that we need to think about very carefully. Obviously, for any element of the bill where there is a breach, there will be penalties, but that's not something that the landlord wants to or needs to face in the future. So this is about understanding what the law will require landlords to do. Now, at the bottom of the screen, there are three elements. One relates to pet insurance, and the fact that tenants, whilst there is no blanket ban, tenants will be given the right to request a pet. Now, the element relating to insurance is that the bill, and obviously moving forward the law, will allow the landlord to request that the tenant has a policy in place that deals with pet damage. Okay, so this is damage that has been caused by pets. So that's another element that we've not had before. So we want to be certain that landlords have a very clear understanding that they need to think very carefully within a certain time frame. From the date that the tenant makes the request, they will have the ability to respond, okay, to make a decision as to whether they will give consent. Now, whilst the focus has been on predominantly the fact that landlords will be asked, there's also another element to consider, and that's the fact that landlords can reasonably refuse consent for pets. Okay, so the legislation will address that element as well. Finally, I'd just like to touch upon enforcement. Now, obviously with new legislation, there are penalties. And what the bill does is provide an outline of the structure in relation to breaches of the legislation or the proposed legislation. There are two key elements that I want to address here. The first element relates to the financial penalties. So the financial penalties will sit at up to $7,000 for a first offence, and then for second or subsequent serious offences, the fine will be up to $40,000. So that's quite onerous for landlords. Those penalties will be imposed and enforcement will be overseen by local authorities. So that's quite a key thing to bear in mind. The other point that I want to address is the rent repayment orders. The rent repayment order is a tenant incentivized penalty. So what does that actually mean in practice? It gives the tenant currently the ability, if the landlord is in breach, for example, of HMO regulations or disrepair, to pursue the landlord through the first tier tribunal. The tenant will apply to the first tier tribunal and request a rent repayment order. Now, that rent repayment order at the moment is currently up to 12 months worth of rent. And the tenant has 12 months to make that claim. In the future, what has been proposed within this bill is that the tenant can make a claim of up to 24 months worth of rent, and they will have 24 months to deal with that claim. So, bringing this element of my presentation to an end, one of the things that I want you to think about is being exposed purely to those kinds of penalties, to that kind of enforcement. And that's one of the reasons that you're here this evening, is to ensure that you do not fall foul of the legislation when it is enforced, when it becomes law. So that's extremely important for you to bear in mind. So let's think about some of the details. So the Renters' Rights Bill, and obviously we don't know if amendments will be made to this part of the bill, but the Renters' Rights Bill will remove fixed term tenancies. So there will no longer be any ASTs. There will no longer be a start date to a tenancy. Sorry, I'll reword that. There will be a start date to a tenancy, but there will be no end date. Okay, so I've given an example that, just for argument's sake, hypothetically, that a tenancy under the new rules will start on the 1st of October 2025, but there will be no end date to that tenancy. The bill removes all ASTs and assured tenancies. So what we will be working with in the future will be the implementation of a new assured periodic tenancy. What does that mean in practice? That means that all your tenancies will run month to month to month. The new tenancy systems will apply to all private residential tenancies. And one of the crucial points to bear in mind here, it's not just your existing tenancies, it's your new tenancies that will convert to the new system. The government have announced, unlike the previous government, that there will be no transitionary period. So I've given you a hypothetical commencement date, and this would be the date when the new law will apply. And I've given you the date of the 1st of October 2025. So that means that all the elements, the majority of the elements being in primary legislation, will apply on that date. We won't have a time frame within which to get prepared for these changes in the future. Okay, so that's very key. And then landlords wishing to move back into the property or wishing to sell would not be able to serve a Section 8 notice under Grounds 1 and Grounds 1A in the first 12 months of a new tenancy. And I stress new tenancy. So I know that one of the other speakers will be addressing the Section 8 process for you. So let's think about some further details. The Section 8 obviously will be amended, and most of the grounds will require a landlord to give 4 months' notice. All the grounds under Section 8 will be evidence-based. They are evidence-based at the moment, but I must stress that the more evidence a landlord has, the better, the easier it is for legal representatives, insurers to deal with a potential claim. Now, serving Section 8 for rent arrears under Ground 8 will mean that the tenant will need to be 3 monthly payments or 13 weeks in arrears. So that's very different to what that Section 8 Ground 8 looks like at the moment. At the moment, the tenant needs to be 2 monthly payments in arrears or 12 weeks. Obviously, as I've mentioned, the landlord must not discriminate against tenants with children or those applicants who are in receipt of benefits. And as I've mentioned, the tenants will have the right by law to request pets. Now, I mentioned the purpose of the committee stage, and one of the key parts of the committee stage is to make amendments to the bill. So the peers in the House of Lords discuss what they feel should change within that bill, these amendments that are extremely important. And one of them is right at the very bottom of your screen of my slide, and that's that landlords cannot request more than the equivalent of 1 month's rent in advance. So that's extremely important to bear in mind. Now, whether that will change or not, only time will tell. We have 3 more days of committee stage, and again, these proposals, that this does not help tenants who may wish to pay rent in advance for lots of different reasons. That needs to be seen whether that will change. So please keep an eye on that one. Obviously, I've mentioned the private rented sector database and also landlord ombudsman, and I'm sure that's going to be a big point of discussion this evening. And one of the key elements for this is that if the landlord's properties are not registered on the private rented sector database, landlords will be unable to rely on a Section 8 that's been served. So they can serve the Section 8, but it won't be valid. So how do you need to get ready? One of the first steps to actually getting ready for the legislation is the fact that you are here. You would not be present if you were not interested and concerned about what you need to do next. So you need to be informed and ready. You need to give due consideration to timeframes. We don't have a date yet for royal assent, but the likelihood is it will be in the summer. It was proposed, assumed that it would have been in June, but it could be July. Okay, so very, very important that we understand that royal assent is when the bill becomes an act. That will give us an indication of the enforcement date. That's the commencement date when this becomes law. And obviously we need to give ourselves time to get ready. So we would hope that the government are mindful that we can't start changing things immediately. We need some time. So we would need new templates. These will be issued by the government. A new how to rent guide, also issued by the government. A new Section 13 notice to deal with rent increases for periodic tenancies, also issued by the government. Elements that you need to think of are the written statement, which will identify to existing tenants and to new tenants that they are now going to be moved over to an assured periodic tenancy. So therefore, you need new contracts. You will also need new template letters to assist you with breaches that may occur throughout the tenancy. So, for example, rent arrears and so on, that reflect the changes in Section 8 and the changes in legislation. Key documents for specific reasons. So, for example, a pet profile for tenants to complete so that you can make a decision and you will know that you may or may not have already decided that you won't allow pets, but you have to go through the correct process to ensure that you are compliant with the legislation. On top of that, you need to be certain that your paperwork is in order for you to deal with database compliance, and you need to ensure that you are registration ready, not only for the database, but also for the property ombudsman. And finally, one of the key elements, and again, you wouldn't be here if point 10 wasn't so important to you, is to protect your business interests. Remember, you are running a business. It's not a hobby. And this is the most significant piece of legislation that we've faced in the last 30 years in the private rented sector. So, my presentation this evening was all about the start of the changes ahead. I do think it is extremely important that you speak to the representatives of Anthony Webb this evening. They will assist you moving forward from today on how to navigate change, how to think about what you need to be doing, and also if you've got to consider the volume of work that needs to be done, so are they. So this is extremely key that you make use of this evening and the people around you. You should really opt for the least stressful option, cost effectiveness versus very costly penalties. So you have solicitors present, you have excellent representatives from referencing companies and insurers, and then you have a good team around you in terms of Anthony Webb. Thank you so much for listening. And again, I'm really, really sorry that I'm not there in person this evening. I hope that you benefit from what's on offer and that you take away some very useful information from this event.
Once again, thank you to Susie. You could probably tell from her voice she is not well. She makes this subject, which, as we all know, is not that interesting, very interesting, and we actually understand it. My team really do well from the training that she gives us. That was an insightful presentation. And even though not quite as planned, Susie's expertise is invaluable. Now I would like to introduce you to our second speaker, Andy Halstead. Andy is the CEO of Barbon Insurance Group and HomeLet, the UK's largest referencing and lettings insurance company, and a landlord himself. His family business manages around 2,000 rental properties, giving him real hands-on insight into the challenges landlords face today. Andy works with over 5,000 letting agents nationwide and understands better than most why professional management, including rent and legal protection, is vital. Please welcome Andy to the stage.
Thank you very much. Having heard everything Susie had to say, I suggest a pub. What do you think? It's a bit grim, isn't it? But maybe we can take some of that away. Now, my objective this evening is that during this presentation, you're going to press the golden buzzer. You know the golden buzzer story about this place? No? The kids from here went on Britain's Got Talent, and they were that brilliant, they got the golden buzzer and went straight through to the final. So you let me know if I'm doing okay, will you? Just. But actually, my real objective is to take away an awful lot of the worry that we've just heard. I'm a landlord just like you, so I would sit where you sit. And I think I've got a pretty good chance of doing that. Because this evening I'm representing HomeLet and actually Anthony Webb. We work in partnership. And at HomeLet, we complete around 1 million references each year. So we've got the ultimate tenant database. If I was advising the government, by the way, I wouldn't be advising them on legislation with landlords. I'd be advising on legislation with tenants, but that's another matter. We do 1 million references a year, so we get an incredible insight into what's going on out there. We don't discriminate either. So it's irrelevant to us. As long as the income that tenants receive is legal, then that's fine by us. So one of the points that Susie raised there was around discrimination. We don't do that. We simply and professionally assess the applicants that come through our process to see whether they are appropriate or not to rent the property that you've invited them to rent. It really is that simple. If only it was. You can't read the detail in there, and please don't worry. That's the kind of detail that goes on behind the scenes when we assess an applicant coming through the Anthony Webb business on your behalf, to make sure that the applicants are who they say they are and can afford the rent that you require for your property. But the thing is, a reference is only as good as the day that we do the reference. And it's very important to know that, because you can't reference the future. It's also important to know that fraudsters are getting better and better and better, much more sophisticated. So much so that these days now we integrate directly with HMRC to try and eliminate as much of that as possible. So when an applicant comes through on your behalf, we actually check their HMRC files live to see whether they have got the pay that they say they've got, and if they're self-employed, they've filed their tax returns, etc. But look, we reference someone today, tomorrow they could die, or the partner could die, they get sick, they can have an accident, they get fired, and it doesn't matter what the circumstances were yesterday. In that day that something like that happens, they can't pay the rent. What are you going to do? Everything that was done to assess that risk up front was done well and professionally, and things still go wrong. And that's where we step in. What I'm going to show you now, very quickly, it's only 2 minutes, but it'll blow your socks off if you don't know that these things can happen. So really quite simply, through Google, nothing else, nothing, this isn't the dark web or anything like that. You get a fraudster who chooses to produce a fraudulent bank statement, or a fraudulent pay slip, or a fraudulent utilities, whatever. Just watch this, because we're going to see somebody do it live on the screen. So this is just normal, going just through a normal Google search. The websites that you see now, they're all free. They don't charge any money. And they're all available to produce fraudulent bank statements, utilities bills, pay slips. And what we're going to do on the screen, as it's showing you, a fraudulent bank statement is actually being put together. So it just shows you how ridiculously easy this is. And I'll put it to you, and I'll bet you any amount of money you want, that if you saw the end product of this, you would not know that it's fraudulent. Because they're that good. It's incredible that this is legal, right? But sorry, I think a bit of internet shopping got in the way when we were doing the... But there you go, nationwide logo, any bank you want, by the way, they're all available. And it's the same for employers if you wanted to create a P60 or a P11D or a payslip. You can doctor it to show any amount of income you want, make sure it shows whoever you've said is your employer, all this kind of stuff. There you go, you get the drift, yeah? That's it. I mean, how is that possible? But it is. And when that lands with us, that's what it looks like. Because every document that we reference on your behalf goes through all of our fraudulent AI processes. So what you can't see with your eyes, we check the pixelation of these documents. We know at what time and on what day that document was actually prepared. We know whether there's any variation in text, and so on and so forth. So when a document that you would look at looks like that to your eyes, all the stuff that's marked up on there is what we see immediately as fraudulent, and then we're able to deal with it as appropriate. So in terms of mitigating risk, then sourcing and selecting the right tenant has got to be the start of that process. What I'm telling you here is a leading tenant referencing business in the UK, that's only one element of it, because it still goes wrong. Fraudsters from time to time do get through. At the minute, we're stopping between 150 than 200 fraudulent applicants every single day. Every day. That's what we're picking up through our process. And I'm not saying that we get it right 100% of the time, because we don't, but we're pretty close. And when things go wrong, they really go wrong. We've heard about all that from Susie's presentation. What it says to me, and I think what's important to you, is that things are going to get worse, not better. So what are we going to do about that? I mean, it's not easy being a landlord now. It's not easy to make a good return on your investment as things stand. And it's going to get more difficult. What do I mean by more difficult? It's going to take a lot longer to get people out of your property, regardless of the circumstances. And that could mean that you just sit on more and more losses. And ultimately, what we're all going to make we're all going to make a commercial decision, aren't we? Is this should I buy British Airways shares, or should I keep investing in property and renting it out? They're the kind of decisions that every one of us in the room can make. And it's really important, I think, that we do invest in property. I think it's such an important sector. But how do we get these risks away? Because if it's going to take, and this is being generous, by the way, because I got an update of our in-house lawyer this afternoon before I came to speak to you. And it's actually more than 3 months now to get a court order in, to get a possession order in Edmonton. It's more like 5 or 6. That's just going to go worse and worse. Look at that. It's 11 months to appoint a bailiff in your area. Do you know this pet legislation? You know, if there is a dog in the property, a bailiff won't go without a dog handler. You can't get a dog handler. You know how much it costs if when a dog handler does go? £600. So, it's not going to get easier. It's going to get harder. What are you going to do about it? That's just quite a conservative guess at what losses you could be sat on if things go wrong. And that's just assuming a rent of £500 a week, which I think is pretty typical in this kind of area. But anyway, you can work out your own numbers. So I ask you a simple question. Number one, can you afford to lose that kind of money if a tenancy goes wrong, and spend that kind of money when you've got no income coming in? But number two, even if you can afford it, why? Why would you want to sit on a loss like that? What is the point of investing if the risk starts to outweigh the reward? That's only a decision you or I can make. That's a personal decision. And it's always been relatively good to invest in property because we get the capital growth as well. Well, that's very questionable at the minute. And when we get a good income. So how do we balance that risk? And I'm saying that is a very significant risk, and it's real. I'm not exaggerating it or anything like that. If you get a difficult tenant who decides not to move out of your property, you will lose a year's rent. No ifs, no buts, probably more. And by the way, some tenants are very good at knowing how to stay in a property. So that's where we step in. Through the Anthony Webb business, we guarantee your rents. Every single penny of it. No excesses, paid from day one of arrears. We guarantee to pay your rents. We're just about to actually change the fact that we've got a 15-month limit on how many months rent we will pay. We're going to take that away in light of this new legislation. Now, you have to have a limit for insurance purposes, so we're moving it to 24 months just to give you real comfort. So there's no limit on the number of months rent that we'll pay, and each and every claim has got a cash limit of 100,000. So in other words, your rent is protected and paid when the rent falls due, if it goes into claim. So your cash flow is protected as well. At the end of the tenancy that's gone wrong, it can often be that the property's been pretty messed up. So you need some time to fix that. Well, we'll pay 75% of the rent for up to 3 months until you get it ready for relet. So in other words, we provide, via the Anthony Webb business, absolute security in terms of you can't lose your rent if the tenancy goes wrong, because we step in and we protect it. It's not just that we protect the rent either, because you can have tenants that stay in properties, continue to pay the rent, but you need to get them out. You need to get them out because you need to sell it, you need to move back in it. There can be loads of reasons why you need to do that. And so long as the tenant is in breach that gives you grounds for possession, we will deal with all of those legal costs on your behalf. It doesn't cost you any money. So we take the worry away, we take the grief away because there's loads of it, and through the Anthony Webb business, we get you vacant possession, even though the rent's coming in. You know, it's not just about protecting against rent arrears, even though that's massive and that's the big commercial risk that we all take. It's also just getting rid of the hassle and getting rid of the grief because you don't have to deal with those circumstances. The cost of this protection through Anthony Webb is £1.30 a day. And you get tax relief on that cost anyway because it's tax deductible. So you heard what Susie had to say, and now you've heard what we can do to help you manage in that new world the risk that you're exposed to. And I have got an additional benefit, by the way. If you don't think that's good value, I've got a list of doctors that you can speak to, and they'll just check out your mental health. Because it just makes no sense to hear what we've just heard and all the other stuff that's going on around the industry at the moment and not spend £1.30 a day and get tax relief on that £1.30 to take the risk, the heartache, the stress away. So I put it to you that it's a no-brainer, and you don't want to leave here without speaking to Tony and figuring out how you can get that covered. I think I'm going to take some questions later, but thank you very much for listening to me.
Thank you, Andy. Another really informative session, particularly about rent and legal protection in place. So start again.
Sorry, I didn't ask. Did I get the buzzer?
Our third and final speaker today is Rosanna Yarlike. Did I get it right this time? Yarlike, there we go. Rosanna is a specialist litigator at Fari Law in Whetstone, with over 15 years' experience working in landlord and tenant law. Tonight, she'll explain how the abolition of Section 21 will change the eviction process, outline common mistakes to avoid, and offer practical advice to legally protect yourself and your investments. Please welcome Rosanna to the stage.
Right, wow. Never spoken to this many people at once before. So, my name is Rosanna Yarlike, and I am a litigator at Fari LLP Solicitors. As Anthony says, yes, I have 15 years worth of experience in the private rented sector. I specialise in landlord-tenant disputes. That's my bread and butter, namely evictions. I operate nationwide and I deal with it all at fixed fees. Where were we? So, Fari LLP Law Firm. We're a local firm of solicitors based just up the road in Whetstone. We deal with litigation, family law, private client, wills and probate, bridging and commercial, residential conveyancing. So the Renters' Rights Bill, when is it coming into force? Well, as Susie explained, we're still at committee stage. No one really knows until we have royal assent, and until that happens, it isn't actually law. Which means that everything comes, which is a perfect opportunity to run through a whistle-stop tour process right now. There are two ways of bringing an assured short-hold tenancy to an end. You have Section 21, which is a 2-month-long notice, and you have the Section 8 route, which is anything up to 2 months' notice, depending on what ground you're relying on. Section 21 is the non-fault route, or what is known as the accelerated route. But please do not be fooled by the name. It isn't particularly fast, as Andy has explained, and also as Susie has explained. It can take anything up to 18 months, sometimes more, to actually get possession of the property. What accelerated means is that there isn't necessarily a hearing. So Section 21 matters are dealt with on the papers. It's what's known as box work. So providing you've done your paperwork correctly, you've dotted the I's and crossed the T's, you should get your order for possession. So the process of Section 21. The notice itself is 2 months long. Once that notice has expired, you can then apply to court for your order for possession. Providing the tenant doesn't put in a defence, you should then be granted your order. If the tenant still doesn't leave, the final stage is then the bailiff. Now, what's important to remember is it varies according to what court you're using. I mean, Edmonton County Court, as Andy said, is taking anything up to 18 months, sometimes a little bit more. And with the Renters' Rights Bill coming in and abolishing Section 21, I'm a little bit concerned, and landlords are only really going to be able to evict tenants for a reason. So it's going to be via the Section 8 route. Section 8 of the Housing Act has 17 grounds at present. 8 of them are mandatory, 9 of them are discretionary, and the notice period varies depending on what ground you're relying on. But it can be anything from immediate, as in no notice, to 2 months. For example, the landlord wants to move into the property. I'm not going to run through all of the grounds, as we're limited on time, but these are the most common grounds. So you have, for example, the landlord wanting the property back for their own use, that's ground 1. The landlord wanting the property back to redevelop the property, that's ground 6. The landlord wanting the property back because of rent arrears, those are grounds 8, 10 and 11. Breach of tenancy, that's ground 12. Antisocial behaviour, nuisance, that's ground 14. Rent arrears by far is the most common that we deal with at FARI. And there are 3 grounds that cover rent arrears, and they are ground 8. This is the mandatory ground, and this means that so long as the tenant owes more than 2 months or 8 weeks worth of rent, if the rent is payable monthly and weekly, or that if the tenant pays the rent every 6 months or annually, they owe more than 3 months, possession is mandatory. Another ground is ground 10. This is a discretionary ground and is used when there is some rent lawfully due, both at the time of serving notice and at the time of the hearing. I'm ahead, aren't I? Sorry. Ground 11. So ground 10 is discretionary, some rent lawfully due. Ground 11 is persistent rent arrears. So I'll give you a little bit of a scenario. When we are faced with a rent arrears case, we will always serve on grounds 8, 10 and 11. And the reason we do that is because 8 is mandatory, 10 and 11 are discretionary. I'll give you a little example. Let's say you have your tenant, the rent is £1,000 a month, it makes it easier maths-wise for me. They owe you £2,000, so 2 months arrears. You serve a Section 8 notice on all 3 grounds. It's listed for a hearing, the hearing is in 4 months' time. They now owe you 6 months' rent, £6,000. 2 weeks before the hearing, Uncle John lends them a little bit of cash. They turn up with a suitcase full of, let's say, £5,000. They now only owe you £1,000. You've lost your mandatory ground 8. That's why we rely on 8, 10 and 11. So even if we lose that mandatory ground, being that they no longer owe 2 months, you can still rely on the discretionary grounds, being the persistently late with the rent and some rent lawfully due. But with Section 21 being abolished, how are we now going to obtain possession? I need to make sure I'm doing it at the right time, you see. So, the Renters' Rights Bill will bring about some changes to Section 8. For example, ground 1 at present is relied upon if the landlord or their spouse requires the property for their own use as their principal home. Ground 1 is going to be extended. So rather than just the landlord and their spouse, it's going to be their family members. So their parents, their children will be able to use the property for their own use. At present, The notice period for ground 1 is 2 months. Unfortunately, when the Renters' Rights Bill comes in, that is going to be extended, and the notice period is then going to be 4 months. Ground 1A is going to be added. This will be relied upon if the landlord wishes to sell the property. Quite a lot of my landlords are thinking of selling up, unfortunately, and we're dealing with quite a lot of evictions at the moment, just so they have vacant possession and they can then sell it on. It's again going to be a 4-month-long notice period, and you cannot serve it within the first 12 months of commencement. Now, the property is going to have to be put on the market, and the landlord will not be able to re-let that property for a period of 12 months if they change their mind about selling or are unable to sell the property. Another key change is to ground 6. So at present, it's to do with redevelopment of the property. You're now going to have to show a genuine intention of redeveloping the property and even show your plans. Again, the notice period is going to be 4 months long, but this ground cannot be relied upon until at least 6 months from commencement. Ground 6B. Now, this is an interesting one. This one is going to be added for when a landlord is subject to enforcement proceedings. So they need possession so as to comply with these enforcement proceedings. This again is going to be a 4-month-long notice, and unfortunately, the court are also going to be able to force, I should say, not enable, force the landlords to actually pay compensation to the tenants as well. Ground 8 is also changing. So at present, notice period is only 2 weeks. That's going to be extended. That's now going to be 4 weeks. Rent arrears at the moment, 2 months. That's going to be increased. So anything over 3 months will only be entitled. So you'll only be able to serve Section 8 on ground 8 if they owe more than 3 months rent. So you're looking at essentially 4 or 5 months before you're actually in court, at least, minimum. Not ideal. Ground 14's threshold in regard to antisocial behaviour, though, is being lowered. So a tenant, instead of needing to be guilty of behaviour causing a nuisance, this will be lowered to behaviour that is likely to cause a nuisance. Not quite sure how they're going to police that, but we'll wait and see. But what concerns me more than anything, really, is that with no Section 21, as Susie has alluded to as well, everything is going to need a hearing. It's all going to have to go to Section 8. And what I'm worried about, really, is whether the court can actually cope with this influx. There will inevitably be court delays. It is already a very slow and painful process. Edmonton County Court, as we've said, taking 18 months. Barnet County Court, another local court to here, is currently undergoing refurbishment work. So their cases are now being dealt with by Willesden County Court. So as you can imagine, everything is just dragging on and on. But until the bill is passed, we continue as we are, and you may want to start thinking about, oh, it did work, getting your ducks in line sooner rather than later, which brings me on to some common mistakes and issues that we see that landlords make. First one, contracts. Do you have the right contract? Very, very important. Is it in a short hold tenancy, or is it a company let? If it's a company let, falls outside of the Housing Act anyway, so the Renters' Rights Bill isn't even going to affect you. You would be surprised at how little how little due diligence some landlords will undertake. For example, if I were to ask you, sir, can I drive your car? Can I take your car for a spin? You'll say, have you got a driving licence? Oh, yes. Have you got insurance? Oh, yeah, fine. Then off you go. Some landlords will not even give them a contract. Simply, here's your 1 month's rent and your deposit. Thanks very much. Here's the keys. That's it. This has a greater value than your car, but yet you'll give more thought to lending your car out than handing the keys out of the property. The other one is deposits. I spoke to a lady earlier today about deposits and issues that they've been having as far as them not being protected in the right way. You've also not only got the issue of protecting it within the 30 days, you need to make sure that prescribed information is correctly served as well. I'm seeing a huge increase in no-win, no-fee claims being made against landlords and us having to do what's called damage limitation, because unfortunately it's strict liability. You've not protected the deposit in time. You've gone through the red light. It was an emergency. I didn't know. I didn't see. I didn't realise. It doesn't matter. You've gone through the red light. You're going to get the fine. You're going to get the points. So what you need to do really is to make sure you have systems in place so that that doesn't happen. The next one, gas safety certificates. So you need to make sure that they are fully compliant. Have they got all the information that they're supposed to have on them? We've had quite a few being questioned recently with the fact that they didn't have the managing agent or the landlord's detail on them. And they're trying to say that they're invalid. Watch this space. I'm yet to be defeated on that, so we'll see. And then there's notices. Are you serving the right type of notice? Has it been served correctly and in accordance with the tenancy agreement? Does it need to be served by hand? Can it be served by post? You've then got disrepair. That's another one where I'm seeing a huge increase in no-win, no-fee claims at the moment. It isn't enough that you simply rent the property out and forget about it. You need to keep on top of everything, any repairs that are needed, any complaints, how quickly you've dealt with them. If access has been denied, will the contractor give you a report as well confirming this? Which leads me on to the importance of having a good team behind you, having a good managing agent like Anthony Webb, and having a good legal team, and I'm going to say Fari LLP as well. We need to make sure that all the paperwork is in order and that systems are in place. I'd also like to give a little shout out, I can't see him at the moment, but to my advocate Martin Wogan. He goes to court for me quite a lot, so he knows that if the paperwork is in place, it will sail through. Your bum barely touches the seat when you're before the judge, but you need to make sure that all the prep work is done beforehand. You've got to remember that this may be your asset, that this is a tenant's home. So you need to work hard to make sure that you keep the odds in your favour. And that's it. So thank you very much for listening. My colleagues and I will be just outside after, and obviously if you have any questions, do please get in touch.
I'm a bit taller, I have to go up here. Thank you, Rosanna. Another excellent presentation. What tonight's speakers have made very clear is this: using a good letting agent is more crucial than ever. At Anthony Webb, we are experts at helping landlords navigate this changing landscape. We are here to protect your property, maximise your investment, and ensure you stay fully compliant so you can enjoy the rewards of being a landlord without the stress. Please do take time to meet my team and the panel after the Q&A in the reception area. Now it's time to do our Q&A. I've got the questions first, and then I've put together a few questions that have been asked by yourselves, the audience, via email when we emailed everyone in the last couple of weeks. And then after that, if there's any time, we'll ask the audience for any further questions. The first one's to do with abolition of Section 21. With the proposed removal of no-fault evictions under Section 21, what specific grounds will landlords have to gain possession of their properties? How will the new possession grounds affect the timeline and process for evicting tenants who are in breach of their tenancy agreements? I understand that I can serve 4-month notice to a tenant after an initial 12-month tenancy. If I put my house up for sale onto the sales market, if the property does not sell, can I then try and rent it out again? Who wants to answer that one?
Yeah. That's quite a long question. I think it very much depends, in fairness, on on everyone's circumstance. As I mentioned in my presentation, if you're looking to sell the property, yes, You can serve the notice, and it's 4 months long. If, however, the property cannot be sold or you change your mind, after the 12-month restricted period, you can then re-let the property, but you will not be able to re-let it any time sooner than that. As far as getting possession is concerned, again, the grounds on Section 8 are going to be extended. I touched on some of them, but there are, goodness, how many?
37?
30, there we go, 37. So quite a lot to go through right now.
Yeah, if you're gonna sell the property, be sure you want to sell it, because that's just beyond ridiculous, is it not? That you put it for sale, you can't sell it, and then you can't rent it out again. So, I mean, who made that up? Also, you can't accept bids on rents, so get your pricing right. You know, if you market the property for 500 a week and somebody offers you 600, you can't take it.
Okay, next question. It's to do with rent increases and market rates. The bill stipulates that rent increases can only occur 12 months after the last rent increase and must align with market rates. How will market rate be determined, and what evidence will landlords need to provide to justify rent increases? What is the process for tenants to challenge rent increases that they believe are excessive, and how can landlords prepare for potential disputes?
I don't think anybody really knows how you do all of that. So it's going to be very interesting to see how it works in practice. What I do know is that the new legislation states that you must serve a Section 13 to get a rent increase in a tenancy agreement, which there won't be any, with rent increases provided for in that agreement. They're all nil and void when this legislation comes in. So you have to serve a notice to have a rent increase. And if this latches on, which it will, all this information, why wouldn't a tenant just automatically challenge that rent increase? Because then it has to go to a court. Well, you can't get a court date. So it'll be at least a year before you can get your rent increase. And even though you've served the notice, they don't have to pay it until the court's heard it to make a decision over it. What I can tell you is our rent guarantee covers that. So if you serve a Section 13 and the tenant appeals it, even during the period up until the appeal, if they don't pay that rent increase, we will. So it's another good way to protect it. But again, it's just another example of how impractical this legislation is. My guess is that it will become normal to challenge a rent increase, because if you think about it from a tenant's point of view, why would you not? There's no consequences. Why would you not?
Okay. Anything else, Rosanna? No? Okay. Next one's on periodic tenancies. All tenancies are set to become periodic under the new legislation. How will this change impact landlords' ability to plan for property sales or renovations? What notice periods are required from tenants and landlords under periodic tenancies, and how do these compare to current fixed-term agreements? If I let my existing assured short-hold tenancy become periodic without renewing, or if I have a 2-year fixed AST starting from, say, March 2025, can the tenancy continue under the old rules?
No, quite simply. Yeah, exactly. So as soon as the bill is passed and it's had royal assent, every contract that you have will turn into a monthly periodic. So it doesn't matter that it's still within its term, unfortunately. What there have been talks of, and we don't know whether it's actually going to come in, is that if you have already served your Section 21 notice, it's looking like they're going to be allowing a 3-month grace period for you to put that into court once the bill is passed. Again, this hasn't happened yet. It's still quite up in the air, but that is one of the proposals that they're trying to put forward.
And going forward, the tenant only has to give 2 months' notice. So you've only, in terms of the plan stuff.
Yeah, that's something that hasn't really been highlighted hugely here. The day after the tenant moves in, the tenant can give you, the landlord, 2 months' notice to leave, which is not like it is today. the other way around for landlords. You can't give notice unless they do something wrong.
For a year.
For a whole year, yes. Right, next question. Right to request pets. Tenants will have the right to request permission to keep pets, and landlords must consider these requests reasonably. What constitutes a reasonable refusal, and can landlords require tenants to obtain pet insurance? My current tenants are paying an extra pet rent. Can this continue under the new rules? Is pet rent still allowed on new tenancies? What happens once tenants with pets vacate, i.e. cleaning, smells, replacement of mattresses, carpets?
There's some legal points on there that I'm sure you'll want to answer, but if you do accept a pet, then it's going to be allowed to insist that appropriate insurance is in place. Now, there's two ways of doing that. The tenant can buy the insurance. The problem there is you've got no control over whether they pay the premiums or not. So how do you know if a claim ever arises and all of that? The other way, and probably by far the best way, is you can buy that insurance and you can insist that the tenant pays for it. So that's probably the best way of going about it if you're going to accept pets. There's some legal points on there. Oh yeah, if you're already taking like a payment to have a pet in, that has to cease immediately. This legislation goes through, even though the pet will still be in.
It is looking like that they're going to amend the Tenant Fees Act so that you will be able to state that they will have to have insurance. But again, as Andy says, doesn't necessarily mean they're actually going to pay. As far as refusing or reasonable refusal of the pet, obviously, if someone has a horse, they're not going to be able to move their horse into the 4th floor flat. Likewise, everyone is going to take into account the superior lease. For example, if it is a block of flats and that superior lease says no pets, then you are within your rights to say no pets, because otherwise you're breaching your own lease.
What about if I, the landlord, am allergic to pets?
Don't get one.
You could try. It's an...
I've heard this one a few times, so it's a wait and see. Okay, next question. Private rented sector database and the Ombudsman. The introduction of a new private rented sector database and landlord ombudsman aims to enhance compliance and dispute resolution. What are the requirements for landlords regarding registration, and what are the consequences of non-compliance? What happens if I do not sign up to the landlord register? Can my managing agent register me on the landlord's behalf on the register? And can my agent update the property records on the register?
Thanks. Yes, the managing agent can register the property on your behalf. If you do not register for the database, then number one, you're not going to be able to get possession of the property under Section 8. It's the only ground that's going to be there anyway. Also, huge fines. I think was it £7,000 for the first time offence, £40,000, that's 40 for repeat offences. Just isn't worth not registering.
As I understand on this, estate agents or any type of marketing for properties will have to have a unique property reference number in the advert. So when you register as a landlord and then you register your property on that register, you will get a unique reference number. That number needs to be in the advert. Even if you're in a pub, you tell someone next to you, I've got a flat to rent out, you need to give them that reference number. The fines are going to be from the local authority. That money doesn't have money at the moment. Local authorities, £7,000 each one. All they need to do is go on Rightmove, Zoopla, On the Market, Gumtree, look for reference numbers. Whoever hasn't got one, £7,000 fine. 28 days later, advert's still there, £40,000 fine. It's big. Next question. Rent repayment orders and penalties. The bill proposes increasing penalties for non-compliance, including higher rent repayment orders? What actions lead to such penalties? Are there any new offences introduced by the bill that landlords must be particularly aware of?
Thanks. So rent repayment orders at the moment are 12 months. So you can get a maximum of 12 months if, for example, there's no licence on the property. That is going to be extended. So it's now going to be 24 months, 2 years worth of rent that you will need to repay to your tenant. Now, I was actually at a talk at a Chambers, and it isn't even just a rent. It's not actually going to be rent repayment. It's going to be a rent payment order. Because get this, if the tenant has not paid the rent, but there is no license, you will have to pay the rent to the tenant because there's no license. Crazy.
And if you say you're going to sell your house, but you're not really, that's one where you'll have to pay all that money out. And if you use any other sort of false reason to get possession, it's highly likely that that's the penalty that you're going to have to pay.
Okay, last 3 questions that I've got here. Transition period and implementation. What is the anticipated timeline for the Renters' Rights Bill to come into effect? And will there be a transition period for landlords to adjust to the new regulations?
I'm not actually sure. The last indication I got was that it would be immediate, but I'm not actually sure. I don't know if you have a better view of that.
At the moment, it is looking like it is going to be. That's it. There's not going to be any kind of flexibility there.
That's exactly what I've heard. So, for example, if this bill becomes law and gets royal assent June, July, which is the likely time scale it's going to become law, they'll set a date. In my office, we're working on a date of the 1st of October of when everything starts. And it gives us 2 or 3 months. Everyone's on their summer holidays in Cyprus, Turkey, Spain, while they have to do all their paperwork. That's what we're going to be working very hard in those few months. It might be later, but I think it's going to be October, November, in my opinion. Number 8, AWAB's law. How will AWAB's law affect landlords following the Renters' Rights Bill?
Yeah. Glad I've done my homework. So AWAB's law, you're going to have very, very strict guidelines and deadlines that you're going to have to meet. Anything to do with damp, disrepair, you will need to keep a very, very accurate record. Sometimes you will have to attend within 24 hours, but you're not going to be able to just have a complaint and not deal with it. You're going to need to deal with these.
It's also currently aimed at social housing, is it not?
Yes.
So the question is that a fact? All right, there you go. So,
yeah, AWAB's law will definitely come into effect under the Renters' Rights Bill for everyone. Currently, it's just for the local authority social housing. Reference issues. If a tenant does not pass referencing criteria, but I still want to give them a chance, can I ask for 1 year's rent up front?
No. And if they don't pass the referencing criteria and you give them a chance, you're crazy. And that's sad, right? Because in a sensible world, why would you not do that to help some people possibly, or you'll take an appropriate risk. But in a world that we've just been discussing this evening, if they don't pass a thorough professional assessment, and if you don't back it up with rent and legal protection, and you let somebody move into your property, you've seen crystal clear what risk you're taking. Why on earth would you do that? You would be crazy.
Okay, if everyone's still okay, we're going to take a couple of questions from the audience. So my colleagues are going to come here with their roaming mics. Oh, there we go. Anyone got a question? Okay, so gentleman here at the front.
Hi.
Oh, okay. All right, we'll take that lady first, then we'll go to the gentleman at the front here.
This working? Yes.
Working over there?
Hi. Thanks for the talks. They've been great. I just wanted to ask about this monthly tenancy thing. So I've had experience where, you get a couple move in, under an AST, and then one moves out or they split up or something. What happens if it's monthly? How do we keep a check on who's in there and that we're still covered with the correct contract monthly?
Are we talking about fees to agents? Or are we talking about...
No, you said that the tenancy is a rolling monthly thing. It's no longer got an end date.
Yeah.
So how would we know as landlords if something's happened in the property without going around them every month?
Well, as agents, when we manage a property, we go around every 6 months and do inspections.
Yeah, but that's 6 months. That's already, they could have moved out 5 months earlier.
They have to give us notice. So that from day 2, I think it's from day 2, or is it from day 1? Day 1, they can give us 2 months' notice to leave. They can't just leave the next day.
No,
So
I mean one of them. You know, like one keeps in the property and carries on, and the other one, like their partner, they split up with them.
Right.
So we have no knowledge until we do our quarterly check.
That can happen today, though, can't it?
Yeah, it does.
Yeah.
That's why I'm thinking, but now I've got a yearly thing, and at the end of the year I can say I'm not renewing. Whereas if it's rolling monthly, how can I cope with that?
Well, would you not renew if there was even if that had happened and they were paying the rent?
Well, what's happened to me is one of them can't afford the rent, so she's now got the council involved, and now they won't pay the full rent, but da-di-da-di-da, it's all, hassle.
Well, exactly that.
And it's not who we rented to and who we did the checks with and all that stuff. All of that now is null and void because she split up with her then husband.
Okay, so in the rent guarantee world, we would pay that rent for you that's not being paid right up until you get legal possession.
So the contract, I mean, without seeing the contract, it's quite difficult, but I'm assuming it's a joint tenancy. So you've got Mr. and Mrs. Mr. leaves, Mrs. is now left behind, doesn't work, now claiming benefits, something like that. It's still joint and severally. It's still a joint and several liability, so you can still hold Mr. accountable for it. But I think the answer to your question is, how do you know on a month to month? Well, the minute you stop getting rent, that's when you can then start putting systems in place to serve the notice.
Right. Okay. Thanks.
So you'd have to bring the contract to an end yourself, unfortunately.
And this national database, where's the protection on that? That we're not just going to get absolutely inundated with spam. Because I'm already quite inundated with spam from local authority selling the info.
Can't answer that, sorry.
Thanks.
Okay, the gentleman here at the front.
Okay, yeah. Sorry. So as a professional service provider and professional landlord, is there any way that we can voice our concerns, probably for most of us, where we can push back?
Every sort of industry body has tried that. I think there's been an enormous amount of lobbying from what I've seen as this legislation's being developed from all kinds of organisations, not least very large landlord representative organisations like the NRLA, etc. And every single bit of it has fallen on deaf ears. So I think
it's one-way traffic.
It's absolutely one-way traffic. I think write to your MP, but honestly, you're wasting your ink. I think the answer is no.
Okay.
This is done, and there ain't anyone listening, even though it's nuts.
So it's basically going to drive people away. If you're
So I can tell you, because we've got this whole market view of what's going on. Lettings transactions this year so far are 15% down. And of course, remember the crisis that this is being caused by the government. If you want to sell your property and you want to get the best price, you need vacant possession first. So the lack of stock in the rental market right now is unbelievable.
Sorry, can this also potentially go back to sitting tenancies?
Oh, I have no idea.
Protected tenancy, basically.
I think not, but...
No, there wouldn't be protected tenancy. You would still be able to evict them, but you'd have to find one of the grounds to fit your circumstances.
Yeah. I've got a question. Sorry, can I ask one question?
Go on then, one question.
With regards to gathering evidence on part letting, or subletting, should we say. I understand, so with your insurance cover, you'll be more than happy to pay for the legal costs and what have you. Certainly from your point of view, to our point, it's fine, but one day you are going to run out some cash or reserves with these outgoing payments. So where would that now leave us landlords, where we're taking our policy review, but a day's going to come along and say, guys, sorry, we're changing the terms and conditions now?
So I think we'll be a long time dead before we hit that.
But I do understand, so you're in business like us.
Yeah, so let me explain. Okay, so here's the truth of the matter. The vast majority of people pay the rent. That's a fact. What we're focusing on this evening, and quite rightly, is the risk. And how do you mitigate that risk? But the truth is, the majority of people pay the rent. We protect rents across, by the end of this year, we will be protecting rents across 250,000 properties. And we're backed by A-rated capital. So unless Britain stops paying its rent, we ain't going to run out of money. Rent guarantee is a regulated business, FCA regulated business. When you buy your rent guarantee, the terms of that rent guarantee cannot change for the period of which you bought it, which is always a year. So you've always got a year's notice if, for example, the premium was going to increase. For example, the risk that we cover was going to change. That can't happen whilst you're insured. It can only happen at the point of renewal. And we've been doing this for 30 years. So if you're worried about rent guarantee not being viable in the future, you sure as hell should buy it, because it means there's going to be one hell of a crisis before we get to that.
In terms of both the people you see here today, my office has dealt with both of them, and every case they've won. Any more questions?
Yeah. Andy.
Hiya.
Sorry, Quinn.
I just have a question with regards to banks. What is their perspective with regard to the bill? And what I mean is, at present, if you're going to remortgage your property, say, for example, I'm in the process of remortgaging and I've got a tenant inside, they're going to ask me for proof of the AST, which is going to confirm the rent amount. So once this changes to a periodic tenancy, there's no guarantee the tenant's going to be living there for 12 months because they can serve you notice within a few months. So what guarantee, what are the banks going to be asking us for? Or are they going to, what are they going to do? Because are they going to make it difficult for us to remortgage now? What is their perspective on?
My understanding is that the banks have to change their terms and conditions to go along with the Renters' Rights Bill.
But they won't making it easier to borrow.
No.
You're absolutely spot on, because what you no longer have is a contract that says, for the next 12 months, I'm owed this much money. Mm. And of course, if they don't pay the rent, that's a debt, and that's a debt that you can pursue. Well, you've only got that for 2 months going forward. So I completely agree. And I'm not sure that's been thought through by the lenders.
Next.
Yes, just Andy. Everything I've heard. Over here.
Oh, yeah. Hello.
Over here.
Yes.
So everything I've heard this evening indicates to me, the ship has sailed in terms of the politics of housing and everything. So it's not really going to be a debate. So everything I've heard today suggests to me that the safeguards for us landlords is going to be insurance, right? I've got two questions for you. One, can you very broadly explain to us what areas you do not foresee covering at this present moment in time? And I appreciate the fact that the legislation is still evolving. The second question, and I get the impression that you're a little bit closer to the game in terms of understanding the legislation as it goes through the House of Lords. What I've heard is that I cannot foresee a situation where there are going to be some aspects of this legislation which are going to be open to judicial review, from what I've heard. Some aspects of it. Are there any areas that you have identified that might sit within that aspect?
First part of the question. What underpins insurance is rent guarantee protection is you've got to have a reasonable chance of winning the case. So where this could go wrong is if you're at fault. So if you're not meeting all of your obligations, then there's some risk in there, because the courts are absolutely aligned to trying to support the tenants. There is literally no doubt. So, you know, a piece of paper being wrong that has no effect on the case whatsoever is enough for some judges to say, sorry, come back and try harder. So that's the area. So I am saying that rent guarantee is a big part of the solution, but even bigger than that, I would argue that having your property professionally managed is crucial. And here's what we find. When a rent guarantee claim comes through from a professional property manager, they're always paid. When a rent guarantee claim comes through directly from a landlord, there can often be real problems. So it just shows you the importance of putting those things together. No, I can't. I mean, if rent isn't being paid, and so long as the landlord is meeting their obligations, I can't see any examples of where we would protect that. The second half of the question, I don't think it will matter what challenge goes in. I think the decisions have been made, and it's almost like blind authority on this. That's been my experience. I don't know if you have a different view of that.
No, I agree. I mean, there's been a lot of suggestions, recommendations, as I said, to do with the 3-month period once you've served the notice and been able to start proceedings. There's been talk of court reform before we scrap Section 21s. I mean, if they can't cope now, how are they going to cope once we can't do that?
I thought there was talk of tribunals too.
There is, but at the moment, that's the problem that we have. Everything is all talk. We don't actually know what they're agreeing on and what is going to be put in place.
The big one's the rent up front, isn't it? That's a big one. That, you know, rent up front covers lots of risk for us. We're just not going to be able to take those risks anymore. So if an applicant doesn't qualify for your property out of, for example, earned or declarable income, or can demonstrate that, you know, they've got that cash to pay, and even if they can demonstrate they've got the cash to pay, it doesn't mean they're going to pay it. And there's nothing like having the cash in the bank on day one. So, you know, it changes that risk assessment. I personally, getting rent up front for a year is something I would consider on my own portfolio. Some of the tenants that where we've done that, I rent to them going forward, absolutely not, because there's no demonstration of their ability to pay beyond what they can show me is in the bank. And if they don't spend that on something else, how do I get the money?
Next question.
Tony.
Over there.
Yeah, just a quick call. It's depressing, whichever way you look at it, especially for people who have been landlords for a long time. But something that, Rosanna, you mentioned, putting the house on the market, and I know from speaking with Martin, a lot of people are going down that road. You have to wait 12 months. Hopefully you'll sell it within those 12 months. If you don't, you can then re-rent it again. If it's the case that you wanted to pass it on to your daughter, your son, whatever, could you use that as a reason to ask the tenants to leave? Because you no longer wanted to be a landlord and you wanted to pass on your investment to your children.
When you say pass on, as in pass on for them to live in it, or pass on for them to then become the landlord?
To gift it to them.
So then they become a landlord. So it'd be
They
their
either become a
investment.
landlord, but they become the owner of the property. Whether they want to keep the tenants or they want
It's
to live in it or
It's
whatever.
likely that you'd probably use the new ground 1A, that it's going to be there for their own use.
Right,
And then because once it's out of your hands, what happens later is,
I've got no control.
yeah, exactly.
Perfect. Thank you.
Okay, this lady down here.
First of all, thank you very much, Tony, for you
Helen.
and the speakers. It's been really informative. I haven't quite slashed my wrists yet. There are, as I see it, these changes are coming on board, but the infrastructure to deal with the changes is not there. So there are going to be massive issues. There are going to be a lot of tenants who won't have properties to rent because, as you've said already, there are landlords who are deciding either to keep their properties empty or to sell. I wanted to ask you specifically about selective license. Given that the database is being introduced, I guess, to ensure that there aren't rogue landlords, will the local authorities still justify charging selective license? I do come from Brent, so we were ahead of the game with Enfield in terms of the monies that they were asking.
I know the answer to that one. They want the money, yes.
I thought you'd say that, Tony.
Licensing is going to stay as it is, but there'll also be the extra element of the landlord database and then the properties on that landlord database. Whether there's going to be charges for all of those, who knows yet?
Thank you.
I think there will be.
Yeah, I assumed there would be. I thought I'd try. Thank you.
Another question?
Hi.
Over there.
So my question is, if you've issued a Section 21 at the moment, but there's a good chance it's going to take about a year to get the tenant out because of the court system, when the law comes in and you're saying we have to change contracts, what happens in that situation when you're in the process of trying to evict somebody? Will we still have to give them a new contract if it's going to take 8 to 12 months?
No, if you're already in court, that's fine.
What if you're not in court yet and maybe you'll be applying for court in the summer?
So, as I said, there's looking to be that 3-month window where you'll be able to then apply.
And we won't have to issue a new contract if the court application...
Providing you've already served the notice, then that's fine. But if you haven't served notice yet, you're out of time. You're stuck, I'm afraid.
Serve notice in terms of issuing Section 21?
Yes, so if you're serving a Section 21 notice, so they live for 6 months.
Yeah.
So say, for example, you serve a Section 21 now,
Yeah.
and in 3 months' time, you decide, not really sure what I want to do. The law gets passed in month 4. You can then apply in month 5 for possession. You're covered.
And the old contract is still in
That's
place?
what it's looking like,
Right, okay.
yes. And again, it will depend.
And I had a second question. There was, I think one of the things they were talking about is if you have a guarantor and somebody passes away, you can no longer go to the guarantors to get the rent payment.
Yes, that is looking like what's going to happen. Yeah.
And that applies across the board. So we have some units in retirement blocks, and often the tenancy ends because the people have passed away.
Yeah.
And often then the guarantors will step in, but we will no longer be able to ask them to pay.
No.
Right, okay, thank you.
Any other questions?
Hi there. Is insurance available for existing tenancies?
Yeah. If it's a managed property, we'll take on that risk so long as basic obligations are met, like under the current law, there's a tenancy agreement, there's no arrears, a deposit's been taken and registered properly. So long as those obligations have been met and there's no arrears at the point where we put you on cover, then through Anthony Webb, we'll take on all existing tenancies.
That's for managed service and rent collection service.
Yeah.
Over here, this gentleman down here. Anyone got a microphone? What would the ombudsman cover? It's basically just going to be a list of landlords. So it's going to be a landlord register, and then I think from what I've gathered today, any tenant disputes that happen, those tenants will go to that landlord ombudsman and say, this landlord that's on your register is not doing things properly.
It doesn't work the other way around.
No. And the one that I've answered lots of times, there's no tenant register.
There is, and we've got it.
This is true. There's plenty of times that we've put a reference up to HomeLet, and within minutes they've come back to us as, we know who these people are, keep away. This is a fraudulent claim. We've things that look perfect, paperwork that looks perfect. We always take 6 months rent, 6 months bank statements, 6 months pay slips, tax returns. We look at it all before we submit it into HomeLet, and then seconds later it comes back, and they already know who these people are because they've gone to agent 1, agent 2, agent 3, until they find the dodgy agent that doesn't charge very much, that doesn't look at the paperwork properly and doesn't use HomeLet. And then they're in that property forever. Not quite, but near enough.
Yeah.
Any other questions? There's a lady over there.
Yeah, can I shout?
Where's the microphones? There we go.
Oh, thanks. Hi. You're talking about the royal assent, and then we're all going to periodic. Is that a new tenancy for which we've got to then wait a year before we can do anything, or is that an old one?
Every tenancy. So basically, once royal assent happens, they'll set a date. That date, 2, 3, 4 months in the future. Once that date happens, every single AST will not be an AST anymore, and would have to either serve a new tenancy, or what was the term? There's a form, a statement. That's what it is. We either have to serve a statement or a brand new tenancy to basically give the tenants the new rules of the new tenancy. Every single tenancy, even if it started the day before.
Okay, so then that's a year as a new tenancy before we can do.
But the rules, for example, if you wanted to sell the property, I'm taking that as an example. If you wanted to sell the property and you've had tenants in there, like the one that I managed for yourself for a number of years, that backdated timescale will still go towards. So you're not going to lose the 5-6 years of tenancy agreement past that you've had there. If you want to sell your property, you don't have to wait a further 12 months. It's only on brand new tenancies, new people, new human beings moving in, basically.
Thank you very much.
So in that example, in that previous example, a tenant's been in there for 5 years, and the renters' rights bill gets royal assent, and the day after that you decide you want to sell the property. How much notice do you need to give them?
4 months.
Just 4 months.
4 months.
Not royal assent. Royal assent is when they say these are the new rules. They'll set a date. Once that date happens, say 1st of October, then it's 4 months notice, as long as they've been there in the past for more than a year or more.
So, first of all, thank you, all of you, to give the information. It's been very helpful. My question is, first of all, to Andy, is a follow-on question. You said you're going to accept existing tenancies which are not under HomeLet. Would then you need the referencing going through, or it has to be managed by Anthony Webb right now for it to be taken?
Yes, the second. We don't worry too much about a previous reference because that was only as good as the day it was done, really. What we worry about is, has the rent been paid during the tenancy, and is it either professionally managed or professionally rent collected, in this instance is even by Anthony Webb? If it is, we'll take on that risk for you, yes.
But if it's managed by the landlord at the moment, but the rent is up to date, it would cover, the HomeLet won't cover it. Is that correct?
No, we would, but that's a different proposition. That's where we deal with a landlord direct. And for example, the circumstances that you're explaining to us, there would be at least a 60-day no claims window. So we try and mitigate our risk in that way. But if it's professionally managed and rent collected by a professional agent, we take that risk on immediate with zero excesses.
Okay, thank you very much. And my second question is to Rosanna. Rosanna, I have a tenant who has been there for like over 8 years. We only did one contract initially, which was an AST, and since then it's been on a periodic. So my question is, with this new law coming in, would the tenants get more sort of benefit because they've been a very long tenant and already on a periodic? And is there any downside of not having regular ASTs, or shall we have regular ASTs?
There's no point in having regular ASTs anymore because they're going to be running on month to month anyway. They won't exist, so there's no point in it.
But because they've been on there for so many years, do they gather more rights in terms of the new law, or is it just the same?
No.
Okay. All right. Perfect. Thank you so much.
Over here.
Question for Andy. Given some of the things you said this evening, do you anticipate, or are you already providing premium discounts for professionally managed properties?
Well, no. So the fee that you pay is set by Anthony Webb. So we don't insure you as an individual. Our insurance insures Anthony Webb, and then Anthony Webb provides a service. So that's how the price is set. That's not in our jurisdiction, unless we do direct to landlord, which is completely different. So,
thank you.
And the Anthony Webb cost, so the cost I showed you this evening is yours, Tony, right? So it's £1.30p a day or £40 a month, whatever it is, but that's the fee, yeah.
Thanks.
A couple of people over here. And I think after these two people, I think we'll close the questions.
Get to the pub.
Sorry, I just wanted to ask, if we have to take out a new contract, once everyone's contract ends, do we have to unprotect the deposit and then reprotect it again?
Good question. I don't know. Look at the shock on everyone's face. No one knows.
I don't think so. No, because it's already protected. Yeah, depends. Yeah, I hate to say it, but it depends.
Right.
Because it depends what deposit protection provider you're using. For example, I think
My
DPS,
deposits, for example.
Right. So my deposits is insurance based. That one.
Mm-hmm.
Yeah. Okay. So it's just the registration that you're doing. So you would probably need to reprotect that or renew your protection for it. But you won't need to take the deposit out and then reprotect it again. You just need to make sure it's renewed.
But if it's...
Yeah. No, so
The My Deposit Protection is an insurance-based thing, so they'll insure you for a year and then automatically unprotect it after a year. That happens now as well. It's not in line with the tenancy. It's from when you protect it. If you're on a custodial scheme, then that protection, they hold the deposit, so that's not you holding it. They hold the deposit. That's unlimited end date. There's one more question. I think there was a lady here. So we'll just pass the microphone down now.
Sorry, before Mrs. Thatcher, there were two types of rent, market rent and registered tribunal rent, and they were both different. And so going forward, if the market is contracting and rents would normally be expected to go up, you're going to be unlucky that some landlords are going to have tribunal registered rents, which might end up being much lower than market rent.
From my understanding, the tribunal is supposed to be setting at market rents. So it's
They
not
never did, but they never did before.
It's going to be a watch this space to see how it actually happens. Is how do you set market rent? How do you? There isn't a database that I know of that tells you what rents are actually being achieved. There's a database of what asking rents were, but that's different to what they're being achieved.
I can help with that. We run a rental index because of the number of volume transactions that's going through our business, and we run that rental index at postcode level. So we will be able to do all kinds of comparables for you and all this kind of thing. What I would say, if I dare, get your rents up as far as you can now.
Okay. I'm going to move over to the lectern. Thank you again for joining us tonight. If you still have questions, myself, my team over there, and our speakers will be available in the reception area. Please enjoy the sandwiches, refreshments, and have a chance to chat. Enjoy the rest of the evening, and thank you very much for coming.